You're listening to Hashtag No Filter with Zack Peter. That's me, your naturally platinum blonde pop culture connoisseur. I'm the reality TV junkie, self-improvement addict, and host with only the hottest tea spilled fresh weekly. For more hot takes, go and give me a follow at Just Plain Zack. I always keep it funny and I always keep it cute. And if you're like me and you want to stay up to date with the latest reality tea, just go and give us a follow at No Filter with Zack on the Instagram. You can always join our private Facebook group. The link is in the description below. Boy, oh boy, do we have a lot to break down today. But first, inspired by all of the wild events that have happened over the weekend, I have a fresh can of Drag Me from my new rosé line with Elix. I partnered with my pals at Elix to bring you a Housewives Watching wine. It is a limited edition rosé. 14% alcohol by volume, but less than a gram of sugar. Drink responsibly, but I assure you, you will probably be getting Liddy City, which is why you definitely should be drinking responsibly. But thank you guys for supporting the wine brand. Thank you for supporting the original OG4 cans. And now we have the new Drag Me cans that are here for a limited edition. So be sure to stock up on them as the new season of Potomac continues to unfold. We also have cans inspired by Atlanta, Beverly Hills, New York, and New Jersey. So you're going to want to go and check those out at nofilterwine.com. Go to nofilterwine.com. All right, so you all love to remind me that no matter how much I may resemble Al Woods, I am no legal expert, which is why I love bringing them on to spit some facts on this show. Today's guest is a certified bankruptcy law specialist and a member of the Chapter 7 Bankruptcy Panel of Trustees appointed by the Office of the United States Trustee, serving the LA Division of the Central District of California. Here to school us today on the Girardi Bankruptcy, please welcome Mr. David M. Goodrich.
Thank you, Zach. Thank you so much for having me today.
How are you doing, David? Are you salivating over this Girardi case as much as we are?
I think because it is in the news quite a bit, it is interesting to follow along with what's going on. For me, it's fascinating to follow because what I do as a bankruptcy lawyer and as a trustee, most people don't understand it and you don't see it in the news very often. So it's kind of fun when one of my fellow colleagues is in the news and has a case that hits a lot of the legal publications and then the local periodicals on basically a weekly basis.
Yeah. So to just before we dive into the conversation and answer a lot of these big legal questions, can you first explain to us what Chapter 7 bankruptcy is and how one even gets to the point of filing for bankruptcy?
Sure. So Chapter 7 ordinarily is a voluntary bankruptcy chapter that you can file if you seek the protection of the court. The goal of a Chapter 7 bankruptcy is to get a discharge of debt. Nearly all debt is dischargeable, excluding a certain couple types of debt. For example, certain tax debt, child support and alimony, debts that are non-dischargeable if a complaint is filed, for example, the commission of fraud, or perhaps the incurring of a financial obligation under false pretenses, including the use of false financial statements. Also, fraud in the fiduciary capacity, for example, a real estate agent or an escrow company that may have stolen money or misappropriated funds. Those types of debts can be non-dischargeable. However, those require a complaint be filed. So the goal in a Chapter 7 is to get a discharge of debt. At the end of the case, which is usually 4 months, the bankruptcy court will enter a discharge of debt, which is a form of an injunction. The injunction prohibits creditors from trying to pursue either a judgment or a debt against the person who filed bankruptcy. In exchange in Chapter 7 for a discharge, frequently assets are made available to be liquidated, and that's what trustees do. I'm a court trustee, and there are, I believe, 40-something trustees in LA, Orange County, and Riverside. And our task is to find assets that can be sold. Sometimes assets are transferred away and those transfers, if not supported by adequate value, or if they were made within a certain period of time, can be recovered. And frequently those assets are like real estate or personal property, and then those items are sold. And so people file bankruptcy for the benefit of getting a discharge so that they no longer have any liability on most debts. And periodically will be giving up an asset to get to that spot. The one issue that it varies by state is whether or not there are exemptions that protect assets. In California, there are generous exemption provisions that allow people who file bankruptcy to keep certain assets. Homes are primarily the asset that a lot of people who file bankruptcy can protect. There's something called the homestead exemption. And there are also personal property exemptions that apply. There are exemptions against income and so forth. So it is part of filing a case is that to get a discharge, you do have to make available your assets. But in California, I'd say about 98% of all cases are what are called no asset cases, meaning nothing is sold by a court trustee. The case processes in about 4 to 5 months. The debtor receives a discharge and the case closes.
Okay, so then is it possible that Tom Girardi filed for bankruptcy to avoid having to pay back a lot of these lawsuits against him? We see former clients suing him for unpaid settlements. We see former business partners now suing him, but we are seeing all of his assets being liquidated. We have his home that's up for sale. We have Girardi cases, everything down to their ice chests and staplers that were put up for auction. Lingerie that they found in his office was put up for auction. Like, they're getting rid of everything. So how did he end up this far into this mess?
So he fits into the window. There aren't very many involuntary bankruptcies. So earlier I pointed out that usually a bankruptcy case is started by the person seeking protection filing a petition for bankruptcy. What happened with Tom Girardi and his law firm is creditors using the powers under 11 USC 303 filed what's called an involuntary petition, which forces him and his law firm were both forced into bankruptcy. They have to prove that a couple of things, whether he's insolvent or his company was insolvent, it's unable to pay its debts, and that they have enough in claims in the aggregate. There's a test. It's either 3 claims with a total amount exceeding $16,750, or there's only 12 total debts and 1 creditor with a debt of $16,750 or more exists. In both cases, the creditor bodies were both able to prove that an involuntary petition was justified, and they provided enough evidence for the court to essentially put Tom Girardi and Girardi Keese into their own bankruptcy cases in Chapter 7.
So it wasn't like he saw all of these debts rising and so he went to file for bankruptcy. He was forced into this, and now everything is being, dug apart and liquidated.
Correct. It's very unusual. And the reason it's unusual is you have to have a variety of things exist in order for it to work. As I mentioned, the creditors need to be a certain amount. And you also, if you're wrong and the case is dismissed, the party seeking to put an individual or corporation into bankruptcy could end up paying attorney's fees to the party or the entity or individual who filed bankruptcy. And that could be thousands, if not hundreds of thousands of dollars. So it's a powerful tool, but it's also very dangerous if you are reckless or you do not have the sufficient information to prove that an individual or entity is insolvent.
Okay. We'll get into the reckless part in a bit because the players involved seem to be a little messy themselves. But can you first explain to me the role of a trustee in a case like this? In this case, it's Elissa Miller. So can you explain what she actually is doing and whether she's working on behalf of Tom or she's working on behalf of the state and what her involvement is?
Okay. So there are 2 trustees. In the Girardi Keese case, it's Elissa Miller. And in Mr. Girardi's case, it's Jason Rund. They're both on the panel of trustees in Los Angeles. It's the same panel that I've been appointed to. So Elissa's job and Jason's job is to collect all assets, whether the assets are already in the possession of Mr. Girardi or his law firm, or if they are in the hands of another party, whether it's a debt that's owed to Mr. Girardi or Girardi Keys, or it's an asset that was transferred away. So let me give you an example. Mr. Girardi's home, it was in his possession when the case was filed. So Elissa does not, I'm sorry, Jason Rund, rather, doesn't need to do anything other than make sure the way is clear to sell the property. And the way that is done is to analyze what the secured debt is, what any kind of claim of exemption there might be that exists, and to determine if the property is sold and the secured debt is paid and the broker's costs are paid and escrow and title is paid and the exemption is paid. Is there anything left over from the sale? If there is, then the property will be sold and the money will come into the bankruptcy trustee's account and be held pending further order of the court for distribution to creditors. Sometimes, however, if there's more secure debt against the property than there's value in the property won't be sold. Occasionally, creditors will go ahead and they will enter into an agreement to give something to the bankruptcy trustee, not personally, but something that the trustee would bring into the estate account that can be used later to pay unsecured creditors. So I don't know if that's what Mr. Rund is doing. It appears there is enough equity in the property. The one issue is there's a judgment lien that was recorded, and that may affect whether or not they can sell the property, or Mr. Rund can. So for Elissa, it's a little different. Her job is to marshal the assets of the law firm and to do a couple of things. One is to recover money that's owed to the law firm, probably by clients. The other is to determine if assets were transferred away, and if so, is there any kind of defense to a recovery of those transfers? So there's two types of transfers that ordinarily are pursued by bankruptcy trustees. First is something called a preference, and usually that is a situation where it's a vendor and the party in bankruptcy, and the vendor received a payment within 90 days of bankruptcy in exchange for goods, and those are usually protected. Sometimes, however, they're not protected depending on the transaction. A transaction that's not ordinary course, in other words, it's kind of out of the blue, where this vendor, let's say, is owed for 6 months of deliveries, and within the 90 days, the party in bankruptcy decides just to make one big payment. Sometimes those can be covered. The other type, which is more in line with what's going on in the Girardi Keys case, are transfers that are made. They used to call them fraudulent transfers. They now call them avoidable transfers, because not all transfers that are, quote, fraudulent transfers are truly fraudulent. Transfers made, for example, a gift. If Mr. Girardi's law firm made a gift to, I don't know, maybe a charity or a client or his estranged wife, those sometimes are not intended to be fraudulent. They were just purely gifts. So at least in California, they changed, actually I think in the federal version too, the nomenclature in the statute went from fraudulent to avoidable. What avoidable transfers really are is if there's not enough value given in exchange for the transfer. Where that is coming up in these cases, I'm sure we'll dig into it more later, with Erika, her companies and Erika allegedly received, and these are not opinions, these are what are alleged facts. They're not, right. They haven't been proven yet.
Right.
But she received money, or her companies received money or gifts. There was jewelry, things like that. And she provided nothing to Girardi Keys in exchange. So that's the kind of general basis for that lawsuit.
And also to clarify, because we hear the term transfers, but these aren't like Tom and whoever was running the books was making a bank transfer from a Girardi Keys bank account into the EJ Global bank account or Erika Jayne's personal bank account. We're now seeing that these were Amex bills and expenses that she just passed off onto him, and we now see that he was using company funds that we now realize are stolen funds or funds that weren't given to, or that clients are claiming weren't given to them. And so it was the Girardi Keese money that was paying for her personal expenses. And that's what we're referring to as transfers, correct?
Right. The bankruptcy code, for purposes of avoidance actions, uses the term transfer, and it is more than just your typical transfer you would think of as a wire transfer or a fund transfer. Transfers can include any interest in property, and even an interest in property is a very broad concept. An interest in property could be your legal interest or your equitable interest, arguably a future interest, although that has been recently shot down. But there are two issues that you bring up: is what is a transfer and what is an interest in property. For her, and in the case, in the claims against Erika Girardi, it is a transfer of interest of property, which would have either been either cash or something acquired by Girardi Keese and then given to her. I think jewelry is one of the items that was in the complaint. Or what they've done is they paid some of her personal expenses, allegedly, and that would also constitute a transfer because that was money that was held in the accounts of Girardi Keese that then subsequently was used to pay an obligation of somebody that's not Girardi Keese, Erika Girardi. So that would constitute a transfer. What is interesting with the Girardi Keese case is whose property was transferred.
Right.
So if you see the allegations, a lot of the money that was held by Girardi Keese appears to have been money that belonged to Girardi Keese clients and not Girardi Keese. So was Girardi Keese's assets transferred? That's going to be a super technical issue. And I imagine there'll be some expert testimony and there'll probably be expert reports regarding, they'll have to do a forensic accounting. Whose money really was this?
Right. So can you explain how the trustees Miller Rund, and special counsel, now we're seeing Ronald Richards, he's in the news very often, he's very active on Twitter. Can you explain how they get paid through all of this and what is it commission? Is it a fee that the state pays?
Yeah, so bankruptcy trustees are federal, I don't want to say they're not agents. It is bankruptcy trustees were created under the bankruptcy code. So it's a federal institution. State of California has nothing to do with the bankruptcy system or bankruptcy trustee. So everything is derivative of the bankruptcy code. And the U.S. Department of Justice, it actually takes the role of appointing a trustee. Sometimes they pick trustee for a specific case, and they don't always need to be on the panel, but they also have a pool of trustees who are on a panel that are available for bankruptcy cases and are assigned cases roughly every 3.5 weeks, depending on what location. To go back to your question, so trustees, the statute is 326, so it's USC 326, that prescribes the way and amount trustees are paid. Usually trustees are paid at the very end of the case, and they're paid a commission based on distributions. The commission structure starts as high as, I think it's roughly 5% when a small amount is distributed, but at some point around $25,000, it levels off at 3%. So for Elissa and Jason, for every distribution they make, they'll get about 3% of that as their commission. But for Mr. Richards, he is employed specially under a true contingency fee basis. And his structure is it's 35% of anything that he recovers before a lawsuit is filed. If a lawsuit is filed, then it goes up to 40%, and it will be 40% of any recovery up until 60 days before trial. And then if he gets within 60 days of trial, anything after that is 45%, and it's the net. So if $100,000 is recovered and there's $10,000 in fees, he'll be paid the $10,000, I'm sorry, in cost, $10,000 in cost, and then the $90,000 that remains, he'll take whatever percentage in that scenario, either it's 35, 40, or 45% is what he gets, and the rest goes back to the bankruptcy trustee to be held for other creditors.
And so he's very boldly claiming that this is all funded out of pocket for him. So to clarify, he does get his expenses as long as they're approved by the judge. Those expenses do get paid, reimbursed to him, correct? On top of his commission.
Correct. The one thing, all contingency fee cases, and also with a lot of bankruptcy trustee cases, lawyers who represent trustees are generally, they're advancing fees and they are carrying the receivable for months, if not years. Without having the numbers in front of me, it's at least a year. So if you take on a case as a trustee's lawyer, you may not be paid for a year. So you have to fund payroll.
Right.
You have to fund all of your fixed costs as a firm, knowing that eventually you'll be paid.
Right.
Hopefully. If you don't recover anything,
that's
you
true.
don't get paid.
Yeah, that's why it's very important that we, focus on our job and, go after the money. So can you explain how Tom is living right now? Because a lot of people are wondering if he claimed he only had 16 or 18,000 in the bank and he, was out of pocket and had all these debts racked up. How is he able to live right now? Because I would imagine he's not living off of that. I believe it's $16,000 or $18,000 that he claims that he only has left.
That's a great question. It really, it's unclear what he's living off of. So ordinarily, after you file bankruptcy, your wages that come in are not bankruptcy of the estate. You live out. Most people who file bankruptcy continue to receive their income at jobs, or maybe it's unemployment benefits, or whatever their income is. They typically keep that money. However, the source of his income, to my knowledge, which is Girardi Keys, is also in bankruptcy. And Girardi Keys and the trustee, Miss Miller, aren't going to be giving him payments, especially when he's not even providing services. At this point, it's my understanding that he is no longer permitted to practice law, so
Right.
he can't do anything that would generate income for Girardi Keys unless they brought him in as some kind of a consultant. For example, we'll pay you $10,000 if you help explain your books and records. But as the owner of the business, he has that obligation already. So you probably wouldn't see a situation where that is happening, but sometimes it does. The other way would be he could be using exempt assets. The funds in the bank account, there are significant funds. And I was looking earlier to see if he's actually even claimed any of those funds as exempt. And I don't think he has. But ordinarily, he would have up to about $30,000 of an exemption in bank accounts if he didn't claim a homestead exemption against his home. But I think he's going to probably claim the homestead exemption because it will be paid up to $600,000 before the judgment lien is paid.
Right.
So that it's, you ask a great question. I don't know how he is funding his post-bankrupt expenses. Maybe he's not. Maybe he's borrowing money from friends. I really don't know.
Yeah, because we know at least Erika is still working, but his source of income was his law firm, which is now in bankruptcy. So it doesn't appear that he has any sort of income. It's a great question that we all want to know. So when the money comes in via liquidated assets or new client settlements or these EJ Global LLC transfers that, Ronald Richards is going after, where does that money typically sit within the estate, and what order of precedence is it used to start paying creditors?
So ordinarily, the money will come into the bankruptcy trustee's account. Frequently, occasionally rather, we'll have multiple accounts depending on if the money needs to be earmarked. Ordinarily, the money will come into one bank account. It's opened up in the name of the trustee, but as essentially the trustee for the benefit of the creditors of that estate. The money usually stays in the account until the final report of the trustee is filed. So when the trustee is completed with liquidation. In other words, every asset has been either abandoned back to the company or individual in bankruptcy, or sold or recovered, whatever it is. Then the trustee will submit a final report that eventually gets to the bankruptcy court. And if the bankruptcy court approves that final report, then distributions are made. Distributions are made pursuant to it's 726 of the bankruptcy code. And the order of priority is it's support, so child support, and I'm sorry, let me go one step up. There's first administrative expenses. So whatever the cost of the estate, the trustee's commission, legal fees, fees for an accountant, fees for a financial advisor, bank fees, sometimes there are bank fees, anything else at that level gets paid first. Then the second priority is alimony, child support, wages up to a certain amount, taxes, things like that are all priority debts. And then finally, general unsecured debts, which are just your ordinary garden variety debts. The one other item, which is not in the code, but which is by statute, well, it's not statute, it's by agreement usually, and it's also protected on Article 9 of the commercial code for California, are secured debts. So if there is a lien, a mortgage, for example, against the property where he lives, his residence, when that's sold, that secured debt has to be paid before any unsecured debt's paid. So the trustees' commissions and the real estate commission and anything else can't be paid until that is paid, unless there's some kind of an agreement with the mortgage holder that it not be paid. But in my experience, that really never happens. The mortgage creditor is in first position unless their lien is subject to potential challenges. For example, they have a faulty deed of trust, or they recorded it in the wrong location, or the wrong asset description. 99% of the time, the lien description or the liens are valid and they get paid usually straight out of escrow.
Okay, and we're seeing now, according to Miller's recent report, we're seeing that there's $49 million of secured debt that he owes.
Right, it's alleged secured debt, and so there are obviously there are two different estates, and there's the one with Girardi Keese, and then the other with his own personal assets. I'm not sure which one has that $50 million. If it's in Elissa's report, then that's in her estate. And some of that has to do with prejudgment liens. There's one, let me see if I have the name here. One of the creditors actually ended up with a judgment lien. It was an interesting name.
Was it the Rui Gomez family?
Yeah, that's it.
Yeah, and it was a $12 million judgment, right? And he paid $1 million, so he still owes 11. So from what I've seen looking at this, they're the only former client of Girardi Keese that was able to get their debt secured. All the other clients that are claiming they never got paid, their debts aren't secured, so they fall into that bottom category.
Right. Most of them will, but here's the one exception. This is what I was alluding to, and I briefly discussed before. Whose money is it? So if you hired me and I was your lawyer and we settled a case and the money that was the payment for the settlement came into my trust account. Trust accounts by operation of law, and trust accounts are heavily monitored, and there's significant consequences for violating your duties as a lawyer vis-a-vis your client. If the money comes into my trust account, it doesn't belong to me. It belongs to you.
Right.
I might have a right to some of that money because we have an agreement, and our agreement says that I get 40% or whatever it is. And I might have an attorney lien, which that's another issue. But setting aside, if you don't have an attorney lien, if the money is sitting in my trust account, it's for you. It's not my money.
Right.
And so that's where it's getting really interesting is there's all the money that purportedly came through the Girardi Keese account and then was paid elsewhere that based on the allegations should have been paid to the clients. So is that money that ever belonged to Girardi Keese? The argument would be, yeah, the portion that was earned by Girardi Keese
right.
would belong to Girardi Keese, and even if it didn't, they probably have an attorney lien based upon their fee agreement. But the remainder never belonged to Girardi Keys. It should never have been taken by Girardi Keys. It belonged to the clients.
So that actually sounds like that could help the clients, because now we're looking at it as it's their money and it was never Girardi Keys money, so they are essentially entitled to it.
Right. The question, I think, and I don't have a lot of, I don't have any actual knowledge of what's going on in the litigation and what's being discussed, but it seems to me if a complaint is filed by Elissa in the Girardi Keys case against a defendant who received money, so Erika Jayne would be a good example, where it gets interesting is whose money was transferred. Was it money that belonged to Girardi Keys? And if so, if there's no defense to the transfer, in other words, it was an avoidable transfer, that there's no defense to the receipt. In other words, it wasn't in exchange for other assets or for services rendered, things like that, probably recoverable. If it was money that belonged to a client and that was transferred to Erika Jayne, can that be recovered by the trustee? I don't know. I don't think it's property of Girardi Keys. I think it's property of whichever client had a vested interest in the money. So I think it's the Gio Gomez or whatever their name is.
Yeah.
Yeah, I would think, and that they're the one exception because they also have a secured right.
Right.
But setting aside the secured right, it could be an argument that they would make is that the trustee shouldn't even be pursuing our money because it belonged to us. So that is our lawsuit. We will sue separately, and that might happen. I've only seen the bankruptcy docket, but I wouldn't be surprised to see some of the lawyers that represent these former clients of Girardi Keys suing directly, avoiding the bankruptcy court. The danger of doing that is without court permission, you may be in violation of the bankruptcy stay, which protects the assets of a bankruptcy estate. So as I mentioned earlier, you get a discharge in Chapter 7 for individuals. And let me make that note. Corporations do not receive discharges in Chapter 7. They're just liquidated, and then when the case is over, they're still liable for any debts that remain. In this situation, the Girardi Keys Corporation, or I don't know if it's a corporation, but Girardi Keys, if it's wound up and the case is over, it still will owe money. So it's important to remember that the obligations will still be there when the cases are over. But setting that aside, getting back to what I was saying is that it's interesting to see how parties proceed in connection with assets that may have never been property of Girardi Keys.
Right. That's an I've never heard it from that angle before, and I think that actually, for me as somebody following the case, that gives me a little more hope that a lot of these clients could possibly end up getting there. Because when you're looking at the bankruptcy and how things are playing out there, it's looking like a lot of the lenders are, because they have their secured debts, they're going to be the ones first in line to get their money. But as you said, it's not Girardi Keys money, so it shouldn't be their money. It's client money, and they're the ones that are entitled to that, which is, the law doesn't always work in the side of morality, though. The law works in the side of the law. So in the report from Elissa Miller, we see that there are several bank accounts listed, and we see all of the assets listed. Now, I noticed that there was a section for real property and a section for personal property. Can you explain what those differences are?
Right. So the real property is you would think real property is residential, commercial property that is real estate. So Mr. Girardi's house is real property. There was a commercial building involved, real property. Everything else is personal property. So bank accounts, cars, household furniture, you can go down the list. Everything else that's not real property is personal property. Also included in personal property are claims. So if Mr. Girardi had a claim against Mrs. Girardi, that would be an asset that is personal property. So it is a very broad. Personal property tends to include just about anything that's not real property. And personal property, you have two types of ownership rights. You have legal and equitable. So it could even be something that is just a claim that hasn't even been filed yet. It could be a future claim sometimes. It depends on when the claim arose. So if Mr. Girardi, let's say, were hurt last year, but he didn't show signs of injury until next year, that could be also an asset that's personal property.
Okay. And so we also see that he had there were a lot of bank accounts listed in the report. I mean, there were a lot of bank accounts. Some of them had figures in them. Some of them had unknown figures in them. What would be like, why would there be so many bank accounts listed? Were some of them trust accounts? Were they all his personal bank accounts? If so, why would he have so many accounts? Can you just explain that breakdown?
Right. So these are both involuntary cases, both Mr. Girardi and the Girardi Keys cases. And that means that the trustee who was appointed in each case is responsible for preparing the schedules of assets. So each have clearly done a great job gathering information. And it's not, I've been a trustee in involuntary cases before. It's really difficult to get information from an entity or individual who's been forced into bankruptcy. So you have to, as trustee, you have to gather the information and put the schedules together and file them. And that's apparently what they've both done. It looks like they've taken everything they've gotten their hands on and probably consulted with their own lawyers and with their own financial people and did the best they could to list all of the assets in each of the cases. If Mr. Girardi filed his own case, very good chance that those schedules would have been more complete because he has the history of the assets. He would know what he owned on the date of the filing. He would know things that the trustees just won't know, and that's just the way it is. And you know, they'll use their discovery devices that meeting of creditors, where is the trustee conducts a meeting and the creditors and Mr. Girardi will show up and can ask questions there, and hopefully Mr. Girardi or his representative is able to tell the trustee the additional information that he or she will need for each of the bankruptcy cases schedules.
Now, I did hear that one of the benefits of him having so many bank accounts could have been that it's possibly standard that people that make a lot of money have multiple bank accounts, because I know the FDIC limit is $250,000. So is it possible that all of these bank accounts were to fund, to protect the multi-million-dollar settlements that he was bringing in each year?
Well, Zach, you probably understand that better than I would. I don't know why he had so many bank accounts. That would make sense to spread your risk amongst different banks so that if there is a bank fallout, we experienced it many years ago when the banks were purportedly too big to fail and then they ended up failing, there was insurance. And that would be a smart play by Mr. Girardi to keep his money spread amongst accounts. There could be other reasons. I can't really speculate on what those reasons would be, but it's not unusual in a bankruptcy case, even the little small cases where the individuals have maybe $5,000 to have four accounts. One may be a savings account, one may be a checking account that they had 20 years ago and they just never closed, and there's a new account. So there could be a variety of things going on why these accounts all exist. And I don't really know exactly what happened and why those accounts are still open and he has so many of them. But I think you probably that might be right, that just to protect that money from loss in the event a bank closes.
Is there a potential tax benefit of having so many bank accounts open?
I really don't like tax and I don't understand it. I don't know. I don't think so.
Okay.
Ordinary income, whether it's income from wages or income from passive sources, in other words, stocks and equity, things like that, it's all reportable. So having the money in a variety of accounts, I don't think would save you any money. But again, I don't really understand tax law and I don't give any advice about it because usually my advice would be wrong.
So we did see that there were a lot of unknowns in the report as well. Unknowns in terms of figures in the bank accounts, just unknown. I saw that word a lot. Like that was probably the most used word in more than Girardi was the word unknown in that report. Is that standard for somebody to file a report during the bankruptcy and have so many unknown figures listed?
Yeah, that goes back to the unusual nature of the filings. They were both involuntary petitions, and the trustees just not having all the information they need to complete the schedules. That those are what I believe to be the reason that they have unknowns, is they just don't have that information yet.
Is it possible that the information is just not recoverable? And how does that affect the case? Because we see Tom, and Tom has, Alzheimer's and dementia now, very suddenly. A lot of the other lawyers and partners are pleading the fifth in a lot of this. So nobody's really trying to support this investigation into the finances. What happens if those figures are remain unknown?
Yeah. So with the law firm, that most likely Mr. Girardi has an accountant or financial advisor who, even though they may plead the fifth, should be required to turn over the records. So most businesses run software programs like QuickBooks or Peachtree, and those records, unless they have been destroyed, which if that has happened, that's another separate non-bankruptcy issue. But if those records still exist, they should be available and could be turned over to the trustee. And then from those records, they might be able to piece together a lot of the unknown categories and amend the schedules to list assets or whatever it is that's missing.
Okay, so let's talk about Erika Girardi, aka Erika Jayne now, because she's being accused of taking or using up to 25 million in Girardi Keith's funds. They're trying to get her to pay that back. Is it possible that she's going to have to pay that full 25 million back? Because I do know that in California, there is a 4-year statute of limitations on personal debts. And being that this 25 million was accumulated over the course of 12 years, is she going to have to pay it all back, or does she have, a loophole that she can possibly jump through?
So the statute you're referring to is it's a statute of limitation on written contracts. In California, a written contract, a collection on a breach of that contract by the other party, you have 4 years from the date of breach. So in other words, let's say a credit card. If you have a credit card agreement and you fail to make a payment in January of this year, the credit card company could declare your breach as early as, and usually it's with credit cards, it's when the last payment was made. So in 2025, February 2025-ish would be when it would be no longer collectible, because there's usually a written agreement with credit card companies. And so that would be the 4-year statute of limitations on a collection action for breach of contract. What we're looking at here, though, with Erika is transfers that she received. And there are a couple of statutes of limitation in under the bankruptcy code. Collection or actions to recover transfers made, you have 2 years from the date of the bankruptcy filing. And so there's plenty of time for those. It will be, if they're filed, there's 2-year statute of limitations. But then there's also California law. So the bankruptcy code has this mechanism under 544B that says if you could pursue an action under state law as a creditor, essentially, the bankruptcy trustee can avail him or herself of those laws and proceed to recover assets or do whatever other actions necessary. Here in California, there are remember I called the fraudulent transfer laws, they're now avoidable transfer laws. The statute is much larger than bankruptcy law. It's 4 years. So they could reach back. Let me make it okay. I mixed them up a bit, though, not on purpose. There's 2 years to file a lawsuit. The reach back is also 2 years under bankruptcy law, which is any transfer made 2 years prior to the bankruptcy filing under bankruptcy law is recoverable. Under California law, it's 4 years looking back from the bankruptcy filing date. It also can be extended up to 7 years if there's a discovery issue. In other words, it could not have been discovered that the transfer was made. Then you could argue that you have a 7-year reach back window. So if Erika received property from Girardi Keiths or Mr. Girardi in the last 7 years and it was hidden from creditors, a lawsuit could be filed to recover those transfers. So there's a big window there. Usually it's hard to show that it couldn't have been discovered. Real estate's a simple example. Real estate, generally, the title in the registrar's office in LA, for example, you'll see the transfer. So it's hard to say, well, it couldn't have discovered that. But money's different. Money sometimes not as easy for a creditor to be able to discover. So she could be looking at a very, and I haven't gone through how far back they were looking in the complaint, but it could be 4 years of asset transfers that they're trying to recover.
But they can't go back. But is it possible for them to go back the full 12 years? Because I think it was 2008 when they first started to see that, and it wasn't even, I believe he was writing them off as loans to her LLC. So he was paying for the expenses. And then on the tax filings, he was saying that it was a loan that Girardi Keese gave to EJ Global LLC.
12 years is unlikely, possibly 10. 10 years would only come into play if there was a tax owed to the federal government during that period, and that tax has not been paid, or debt rather. So usually it's IRS debt, 99% of the time, or there could be other debts owed to the government. If the government is owed money, there is a provision in it's called the Federal Debt Collection Practices Act that allows the U.S. government to go back 10 years if it needs to. Let me take that back. It's 6 years. Sorry. It's 6 years for the U.S. government that it could go back. And then there might be an extension beyond that. I think there's a discovery rule. But anyway, there's a larger period of time that they may be able to go back. And then there's another whole area of law that's still a little murky, where transfers made the other party are held essentially in trust. In other words, let's say Mr. Girardi transferred something to Erika, and Erika was holding on to that property with the understanding that it would be returned to him once his debt issues were resolved. That's also a possibility, and you could go much further back in that situation. It's unlikely, though, that scenario exists. I'm just assuming, but I don't know. I don't know. Those are very hard to prove, those kinds of cases.
Is it possible that she herself could file for bankruptcy to avoid having to pay for this debt?
She definitely could file bankruptcy. Depends on what her goal is. I don't know what her assets are currently, so that would be the first issues. Does she have assets that could be liquidated to pay claims, and is she willing to avail herself of the benefits of bankruptcy by sacrificing assets? So if there's something that she owns of value, maybe the stock interest in these corporations that she owns, those could be sold, or it could be transferred by the trustee in a sale. And then the amount recovered from that would be paid to her creditors. Whether or not she gets a discharge of all debt would be another issue. She could face non-dischargeability actions from some or all of the creditors, including both trustees could file complaints to have the discharge of the debt owed to the estates determined to be non-dischargeable. Typical grounds are fraud, conversion of assets. So conversion is a nice way of saying embezzlement or theft. So an asset was taken that should not have been taken. In other words, there was no consideration, or perhaps it was taken without even knowledge. There's also what I briefly talked about, the false financial statements. Very unlikely here that there are false financial statements that were provided to Girardi Keese, but maybe, I don't know. Also, defalcation in a fiduciary capacity. I don't know if the wife of a principal in a law firm would have fiduciary duty to its clients, but that could be something that could be raised as a possible claim against Erika Girardi if she filed bankruptcy. And then there's always the worst of all scenarios in Chapter 7 is a complaint to deny discharge. And that's also a possibility. So she could go into bankruptcy, and I don't know whether or not she would discharge everything that she owes. Maybe some of it, maybe none of it, maybe all of it. It's hard to say how aggressive some of these creditors would be. And the other piece that you always have to figure when you're going after a party for a judgment, usually to collect money, would you ever be able to collect money? Is there any point in getting a judgment if someone like Erika Girardi may not have any assets in the future? But I think she does. She's on a television show. She probably has residual rights, royalty rights, and so there's value there. So these creditors, if she filed personal bankruptcy, including the two trustees, could be very aggressive, and they may ask that their debts be determined to be non-dischargeable.
So it's likely she's not getting out of this mess anytime soon. They're going to pursue, I would imagine they would pursue this as long as they can.
Yeah, good question. I don't know. There is something that all trustees are required to do, which is to do a liquidation as quickly as possible. So protracted litigation is not exactly, it doesn't fulfill the duty. If you're in a lawsuit for 10 years, you're not breaching your duty, but you're not expediting and liquidating efficiently assets. So it's very likely over the next year or two that there will be mediations and settlement discussions with Erika and her lawyers that result in settlements with these bankruptcy trustees. But I don't know. I don't know if she has so much in assets that she'd be willing to pay a big chunk of money or just want to fight it to the death. And then don't forget, like I said before, it may not be over when these cases are over. There could be the other piece, which might be these clients of Girardi Keese going after her directly.
Yeah.
And her companies as well.
So is her divorcing Tom, because we saw that she filed for divorce last fall, is her divorcing Tom then also relinquishing the assets, like the property that they own together? Or is she still, like, how is she still involved, being that she's filed for divorce, but they're not legally divorced and her name was on some of those properties?
So it depends on what happens in the divorce proceeding. If the Girardis go to trial and a family law judge is required to enter judgment dividing up their marital estate, giving whatever to Mr. Girardi and whatever to Mrs. Girardi, that's one thing. It would be interesting to see. The first step would be proceeding in that manner, because right now Mr. Girardi's assets are frozen in bankruptcy court. The bankruptcy stay would prevent the state family law judge from doing something like that. But if the bankruptcy court gave relief from that stay for purposes of dividing up the marital estate in state family law court, then that could happen. And then if a judgment's entered, then the bankruptcy trustee in Mr. Girardi's case would have to abide by that judgment. So in other words, if Erika Girardi were awarded the home, then that home would no longer be part of the estate. Very unlikely that that ever happens during the bankruptcy case. The other possibility is that Mr. Girardi and Mrs. Girardi enter into a marital settlement agreement where Mr. Girardi transfers certain assets to her in exchange for other assets. Depending on how that's structured, it may or may not be an avoidable transfer. Although it would be a post-petition transfer, it would still be a transfer of assets without the blessing of the bankruptcy court and the involvement of the bankruptcy trustee. That will probably never happen because Mr. Girardi doesn't have the authority to give away any of his assets at this point. He'd have to have the bankruptcy trustee involved. When the bankruptcy case was filed, think of it as if for Mr. Girardi, once the order for relief was entered, the bankruptcy trustee, Mr. Runn, is now the kind of fictional owner of his assets. And so as a fictional owner, he has the sole and exclusive authority to dispose of assets. But he also has to ask the bankruptcy court for permission to do these things. He can't just start getting rid of assets. He has to go through a process. Same is true with Girardi Keese. If there was any asset in Girardi Keese that Mr. Girardi wanted to use in a marital settlement, it would have to go through Ms. Miller. And then the bankruptcy court would have to approve it on top of that. So the effect of the divorce for purposes of settling up on assets you probably won't see anything for years. It's very unlikely. Now, perhaps there are assets that Mr. Girardi will claim as exempt. He may be able to use those assets because exempt assets that have no equity beyond the value of the asset typically get abandoned by the court trustee at some point in the case. And once that's happened, Mr. Girardi will be able to use those assets as he pleases. But at this point, his major assets most likely will stay with the bankruptcy trustee and will be used to pay creditors.
And it's looking like when it comes to Erika and her being sued by by Tom's personal estate, not the Girardi Keese estate. We know Girardi Keese is going after her for the $25 million, but it looks like the personal estate is also going after her, and they want her to hand over any communal property that she may be in possession of. That I would assume would be like jewelry, very expensive clothes or shoes, furniture. She hasn't turned any of that over. Is it possible that that's the legal strategy to hold on to as many assets before we move into mediation, where then she would likely have to fork over some of that stuff? Or does she really just think she's entitled to all of it because they're all gifts from Tom?
So California is a community property state, and community property law is an interesting area of law. It's very complicated. Ownership rights essentially are determined pre-marriage, post-marriage. And then there's also could be an intervening premarital agreement, sometimes post-marital agreement. So those are all the different ingredients in an asset situation where you have husband and wife. Assets acquired during marriage, unless there's an agreement to the contrary, are community assets, meaning they each own an interest in the asset. So the jewelry, he may have given it to her, but without an agreement, and with that agreement, either a statement in writing signed by Mr. Girardi that it's a gift and that it is not, he's waiving any rights to the property. Most likely it's community property. So at least some portion of that asset still belongs to Mr. Girardi.
Interesting. So is it possible that she's just holding on to it until, because she's likely going to have to forfeit something at some point? Is it possible that the reason she's holding on to all the assets is to wait for that mediation to happen in the future?
That might be her strategy. I don't know. There's the old adage, possession is 9/10 of the law. With personal property, I don't know that necessarily is true, but it's her strategy. Okay, I really don't know why that would be the strategy, but other than it's probably personal to her, there's probably some level of emotion and some level of entitlement because it was given. If your significant other gave you something, even if you were married, you probably feel that that was your asset. That belongs to you. They gave it to you. But the way the law works in California, it's not so clear on that issue. It's not necessarily correct.
And now on the show on Real Housewives of Beverly Hills, she's playing the narrative that she really didn't know anything. But I just want to clarify that, and correct me if I'm wrong, even if she didn't know anything, whether she knew anything or not doesn't really matter. She's still technically on the line if they find her, if they find that the money does link back to her.
So the avoidable transfers section of the law, there is an intent aspect. There's two ways. One is that Mr. Girardi would be the one, his intent matters. So did he intend to transfer an asset from Girardi Keese or from his own personal asset pool to her? Was essentially the goal of protecting the asset from the creditor. Then there's the other aspect where it's called constructive fraud, where, given a variety of factors, adding those factors up, is there indicia of fraud? Or was the transfer just for less than equivalent value, reasonably equivalent value? So there's different tests. So she doesn't necessarily have to have intended to take an asset with the goal of depriving Girardi Keese or of his own personal creditors, and then have, if she didn't intend to take it to essentially, I don't want to say defraud, but to deprive those creditors of that asset, even if she didn't know, that asset can be recovered.
Right.
It happens frequently.
Wow. Lots to break down, David. Thank you so much for your time, for taking the hour to break down a lot of these questions and explain bankruptcy to a lot of us, myself included. I'm learning a lot through all of this. I feel like I'm in law school learning as much as I have over this past year. So thank you for your time, for coming on the show today.
I appreciate you having me. Thank you so much.
Ooh, wow. That was a lot to break down. Thank you so much, David Goodrich, for chatting with me today. That I learned a lot. I'm pretty sure I'm going to have to watch this episode like 3 more times to fully digest all of that information. I hope you do as well. And while you're there listening to this, I hope you leave me a nice 5-star review on iTunes. If you're watching this on YouTube, hit that subscribe button and that bell notification button. That way, all of the tea is always served to you fresh, and you get a nice little notification when there's a new episode dropping on #NoFilter with Zack Peter. That's me. You can give me a follow at JustPlainZack. Follow the podcast at NoFilter with Zack on the Instagram. Join our private Facebook group. The link is in the description below. We go live. We do book club on Instagram every Tuesday at 6:30 p.m. Pacific, 9:30 Eastern, and every Thursday, same time, 6:30 Pacific, 9:30 Eastern. We go live on the Instagram. Get my #NoFilter1 at nofilter1.com. Lots of fun designs that you can enjoy while you're watching Housewives this summer going into this fall. So cheers to a lot more content to come. I'll talk to you guys next week or tomorrow night on Instagram Live. All right. Bye.